Good morning, everyone. I still see we have a number of people joining us, so to allow for that, I'll just do a few introductions. This is the first in the King's Chambers commercial series for 2025, which is looking at aspects of breach of warranty claims. Tina and I are the first partnership to be sent out there. I leave it to you to judge in Ryder Cut terms as to whether or not we start off strongly, weakly or mediocre. But we're the first ones to go, and there'll be other talks which will be coming up over the next week or so. Just to let you know that after this seminar, we will be sending out the recording and the slides. So you'll have that, and that will be sent to even those who have not attended but have signed up. The reason why we decided to look at this series of talks was it was the experience across the department that over the last year or so we've been seeing an increase in these types of claims. And the motivation for Tina and I's talk especially was the fact that we're seeing vagaries in drafting which are causing implications in enforcing these types of claim. Whilst I'll be doing the majority of the speaking, this is a presentation that Tina and I have prepared together, and Tina will sweep up at the end with the last parts when dealing with mitigation and indemnities. There is a chat function which we will try and monitor and as time permits answer those, but please feel free if you do have any questions to either send it back with a feedback form or to contact us directly in Chambers. We'll be more than happy to answer. So with no further ado, we'll kick off. And our topic of ours today is construction of warranties and indemnities. So what are we talking about? Well, warranties are contractual promises about a factual position. Parties will look to use the same, for example, in asset or share purchase agreements. So there's a factually stated position as to, for example, the quality and extent of what is being purchased, with the risk of a particular state of affairs existing or not existing being allocated between the parties. And that principle needs to be at the forefront of minds when considering what warranties are required and the terms the same. Warranties can be expressly set out in a contract, or they can be implied, for example, as a matter of statute. This talk is going to be concerned solely with warranties expressly set out in a contract. One thing to bear in mind is that unless it has been agreed between the parties that a pre-contract representation will be deemed to be a representation for the purposes of a misrepresentation claim, a breach of warranty claim does not give rise to a claim in misrepresentation. Another thing to look at is when a party wishes another party to verify propositions which the former has prepared, then that amounts to the giving of warranties and not the making of misrepresentations. And strike law that a breach of warranty claim is actionable as a breach of contract. So just going back there, an indemnity, which we're also considering here, that an indemnity is a contractual promise where one party agrees to reimburse the other for losses suffered in a stated set of circumstances. There is no magic to the principles of construction and interpretation. It used to be believed that if you had an indemnity, special rules govern the interpretation and construction of indemnities. The same with warranties. That is not the case, and we've given you the authorities there as regards warranties and indemnities. You'll be applying the principles of contractual construction and interpretation laid down in Wood and Capita Insurance Services Limited. And we would recommend for essential reading is the Finsbury Food Group PLC and Access Corporate Capital for a complete summary of the principles. What is worth bearing in mind in relation to the point I just made about there being no set rules as regards the construction of indemnities or warranties is the decision in Genworth, AXA SA and Genworth Financial Holdings at 65, is basically you mustn't have a situation where the tail is wagging the dog. And therefore, you mustn't start with the potential consequences of a conclusion as to a particular construction or interpretation of a warranty or indemnity as to what a contract means should not drive the very construction exercise to be undertaken in the first place. So clearly you're applying straightforward contractual principles of construction. That said, there is one vagary in this regard, is you will often get a case where you have an indemnity which is addressed to a breach of warranty claim. In those circumstances, it's necessary to construe the indemnity in the light of the warranty it is serving. Now, I'm going to ask my Welsh-speaking colleague and first pupil as to whether or not she would like to read out the Welsh name of the authority there that we're going to have.
Happy to oblige there. So it's Gwynter versus Gwynter, which actually translated, rather relevant to the facts of that case, just means sea wind or wind from the sea. Which is absolutely for the facts of that case, which involved wind turbines off the North Wales coast.
Exactly. And the warranties given in that case was that the wind turbines would not suffer, were all in a good state of repair and had not been damaged. And there was given a warranty to that effect by the vendors. There was an indemnity as well, which said that if any of the assets are destroyed or damaged prior to completion, then not just the vendors, but the operating company would agree to indemnify the purchaser against the full cost of reinstatement of the particular wind turbines. In that case, there was clearly a breach of warranty, but what was being argued by the purchasers was, provided they could establish the breach of warranty, the indemnity also extended to cover the costs of reinstating the turbines in relation to damage, whether it was suffered in breach of warranty or not. So in one case, for instance, there'd been some damage pre-completion, but there'd also been damage to the turbines which had been caused by natural wear and tear and corrosion post-completion. And the vendors in that case argued, well, the indemnity can only relate to the warranty. We can only be obliged to indemnify for damage which we said was not in place pre-completion. And the court upheld that as being correct. It said the indemnity only makes sense alongside the warranty. If you had an all-encompassing warranty, which meant, an all-encompassing indemnity, which meant that the sellers were obliged to indemnify you for any damage whatsoever, the cost of reinstating any damage whatsoever, then it would render the warranty given as to no pre-completion damage absolutely irrelevant. So that was an approach which was taken there. We've given you the primary scope of construction principle, which will be familiar to most on this call, that the construction interpretation exercise is giving effect to the plain and obvious objective meaning of the words used. And that is particularly relevant in cases which you most likely to come off where warranties will have been professionally drafted with parties, commercial arm's length parties, with the benefit of in-depth legal advice and representation. Because of that, there's limited scope for the application of business or common sense, and little or no scope for the implication of terms. One point case to note, however, is a rare example where terms were implied into a professionally drawn contract is the case of Zedra Trust Company, Jersey Limited, and that case will be is in the handout, which will be provided to you after. One thing to bear in mind when looking at warranty, as with any contractual clause case or indemnity, if you believe there's a risk that your construction and interpretation is not, the exercise is not going to produce the true agreement, then you need to be looking early on as to whether or not you need to be rectifying any terms of the contract or the warranty. This is really our non-contentious friends, and I hope there are some on the call, they always get annoyed with litigators because we always turn around and try and give them guidance as to how they should carry out their job. But really, we're doing it informed from the basis that we're always the ones who are left to enforce this. And suddenly we're the ones faced with arguments as to the construction, interpretation, application of warranties, which were probably envisaged. So what we're setting out here in section C is a few issues that we believe are relevant to consider when looking at the provision of warranties. The first point is always going to be, who are the persons who are going to give the warranties? Now, there's no limit on who can give the warranties. They don't need to be a person receiving consideration under it necessarily. And they don't need to be limited to people who have the best knowledge. It's all going to come down to the particular case as to who the purchaser believes who they want to basically be nailing their colours to the mast in warranting what about the company which is relevant to their decision to purchase. What if you are acting for parties or persons who are looking to provide warranties, then it's going to be essential that you engage with them as to what facts they are actually able or prepared to warrant and what protections, if any, they believe they need in place to limit their responsibility. For instance, do they only have a particular area of knowledge? If so, you may want to give some thought as to limiting the warranty they're giving by reference to that particular area of knowledge. So that is a relevant factor. I've done a case recently where they required one of the directors only to be specified giving warranties as regards particulars of issues which arose in his particular department, either sales department. They'd originally wanted warranties from him for every aspect of the business, but he said, look, I've got the usual knowledge of a director, but I don't have any better knowledge than my colleagues. I'm happy to provide warranties as to my particular area of the business. And in that case, they were happy to proceed on that basis. Another issue which is arising is at what date are the relevant warranties given? And this is fundamental because usually you'll be warranting a state of affairs at a particular point in time. And often you'll get it is warranted at the date of the agreement. But the Belfairs Management Authority is an interesting one in this regard, because in that case, the relevant warranties were expressed as being operative at the date of the agreement. However, the agreement was signed by the purchasers on the 1st of February, but the warrantors didn't sign until the 11th of February. Now, in that case, the parties proceeded on the common basis before the court that the appropriate date was the 11th of February. But the judge in that case, Mr. Justice Norris, as he then was, believed, well, I'm not going to go behind that agreement, but I do believe there could be a respectable argument for it being the 1st of February or the 11th of February. So when factoring this in, be clear if you're giving a date as to the date when the warranty is operative, be clear as to how that date is to be defined, especially if there's to be a gap between exchange and completion, or there could be different dates on which the parties signed. Linked in with the area that we considered earlier about who are persons giving the warranties, you do need to always consider as to whether warranties are to be qualified. For this reason, the starting point is absent clear words to the contrary, a breach of warranty is to be judged by an objective standard. And unless the warranty is qualified, the warrantor assumes responsibility for the warranted state of affairs, irrespective of their own knowledge of the actual state of affairs. So going back to the position of the sales director, doesn't matter if they'd insisted on a warranty being given by him and he'd warranted what the state of play was in another department, say in the IT department, and something which he warranted turned out not to be correct. Doesn't matter that he didn't have the knowledge unless the warranty was qualified in that regard. So that needs to be borne in mind. And we've said if it's going to be qualified, you're going to need a clear words. And I think this is going to be addressed in Andrew Grantham's talk later on as to proving breach in such situations. One thing also needs to be considered is sometimes if you're acting for a party who is asking for these warranties and you're asking you want some assurance as to what state of investigations the party provided the warranty is undertaken. And the thing that you begin to see in agreements is that where a warranty is qualified by an individual's particular knowledge, this is by reference to the warrantor's particular knowledge, that there's a term in play that everybody is proceeding on the basis that before giving the warranties, the individual providing the warranties will have undertaken inquiries of specific identified individuals, so that they've got the assurance there that, okay, it's okay, you're going to limit it to your knowledge, but we expect your knowledge to be informed by inquiries that you've made of specific identified individuals. Potential pitfalls are coming out in the authorities now is parties using expressions and terms which aren't actually don't have an agreed meaning and are capable of different meanings. And one example we give there is Finsbury Food, where in that case, they just used the words material adverse change. And there was disputes between the parties as what material meant, what adverse meant, and how change was to be judged. You may have a change, but what is the position what is the starting position, and what is the end position when you're considering change? And that caused a number of issues of confusion in Finsbury Food. An example where they got it half right is the decision including Holdings Proprietary Limited and Garbett, where in that case they had the phrase material adverse impact. And they defined that in terms of, if giving an example, one of the warranties related to a material adverse impact on operating income. And the agreed definition was there would be deemed to be a material adverse impact on operating income if there had been a percentage reduction of 20%. I thought that's very helpful. But then as the judge points out in that case, but from what? There was no agreement in the contract as to what the starting point was for judging whether or not there'd been a reduction in 20% of the operating income. What was to be treated as to the defining benchmark for then assessing whether or not there'd been a deterioration by way of 20%. So the court in KitKat and others, M&S UK Holdings and others, say, look where you're using phrases like this to consider using contractual definitions and contractual parameters, because you've got to be aware in these cases there's going to be competing understandings as to what is meant by particular phrases or particular terms, and those, whether they exist at the date of the agreement, they'll certainly come out if there's a claim for breach of warranty later on, because some smart lawyer will look at it and go, well, does that mean exactly what they're contending it means? And Primus Holdings is a classic example in that regard, because there were competing understandings by the parties as to what was meant by the words, quotes, in respect of lost goodwill. The claimant in that case argued it meant the good name, business reputation and connections of the business, whereas the defendant argued that it meant good name and public reputation of the business concerned, local reputation of the business in question. And the defendant's argument was the one which was accepted by the court. So again, you can see why in that case the claimant suffered they believed there'd been something it was unaware of in breach of warranty which impacted on goodwill, but it really had to stretch the definition of goodwill to mean its connections and its reputation beyond its local reputation. And the defendant had an easy argument there to say, well, that's not what it's defined as. Goodwill is as it's ordinarily, properly understood to mean, and that is good name and public reputation in the local area. So again, another example of where you might want to consider having particular terms defined. Moving on, the next area which is often covered by warranties is future events. A warrant party purchasing a business will often want to have a warranty given as to the future prospects of a business or the future occurrence of future events. You've got to be really careful. Whilst it is possible to give a warranty that a particular future event will occur, you're always going to tend to avoid trying to give that, because the matters over which the warrantor will have no control. But when drafting a forecast, you've got to be a warranty in respect of future events. You've got to make sure your client could not be taken to be warranting the occurrence of a future event. What you're more likely to do is to be looking at warranting forecasts and warranting that they are fair and accurate, or warranting that they've been prepared on proper accepted bases and methods so as to produce what is believed to be a reasonable forecast. What you must use is clear words to ensure that there can be no arguments that your client is warranting the outcome which is set out in those forecasts. And a good example as to what can happen in these cases, Lion Nathan Limited and CC Bottlers. In that case, the warranty was the forecast results are achievable. At first instance, the High Court judge concluded that that was a warranty, that the forecast results were reasonably capable of being achieved. The Court of Appeal disagreed with that construction and said, the Privy Council disagreed with that construction, and it construed it as a warranty that reasonable care had been taken in the preparation of the underlying material of the forecasts. You don't want to be in a situation where the meaning of your warranty is going all the way up to the Privy Council, Supreme Court, or the Court of Appeal. You need to be precisely clear as to precisely what you're warranting as regards future prospects and spelling it out. And Lion Nathan is a good example there of the different options which are available. Relations with third parties also link in, and that comes back to the Belfairs Authority. And sometimes we're seeing more and more wider terminology and words being used in warranties, especially when it deals with relations with third parties. In that case, a warranty was given as the ability of the company to fulfill obligations under agreements, arrangements, or contracts with third parties. Now, in that case, the company had entered into a contract with the NHS, but the contract post-dated the date of the warranty. So the warrantors thought they were clear of any issues which might arise into that contract. But what happened was, although it had only entered into the contract after the warranties, it had been told prior to the warranty being provided by the NHS that it would be awarded the contract. And the Court of Appeal found in that case that it fell within the arrangements with the NHS, fell within the arrangements, because whilst it might not have been a contract, it was clearly an arrangement. They believed it was wide enough to cover. In effect, they had an arrangement in place with the NHS that they would be entering into a contract in the future to deal with it, and therefore they had to, the purchaser in that case was entitled to advance the breach of warranty claim that there were issues which were going to impact on their ability to fulfill the obligations. So be very careful in using wide words. We always, as lawyers, raise the eyebrows in litigation when we see things like the use of words agreements or contracts. What's the difference? What's the arrangements? They're clearly being used as a sweep-all to cover everything, and that then impacts on what advice you give to your client, in particular the person providing the warranty, as to what could be covered by this material. For instance, it could have been merely discussions they were having at that time with somebody which they believe was going to come into fruition post-contract. So be very careful of loose language in that regard. Final point which I'm going to cover is under the accounts. Now, account warranties are pretty standard, and it's usually going to be that the accounts have been prepared, management and year-end accounts have been prepared in accordance with relevant standards. Can I direct your attention to the Macquarie International Investments and Glencore UK Limited case? And that was a case where such warranties were given, and it was discovered after the completion of the contract that actually the financial position was not as stated in the account because certain third-party debts had not been recorded in the accounts, and a breach of warranty claim was brought. However, the breach of warranty claim did not succeed because the third-party debt had not been recorded in the accounts due to a billing error, and therefore the company didn't know of the same, and therefore the accounts didn't include the same, but there'd been no failure in the process or the accounting standards which had been followed to prepare the accounts. So look as to whether or not there could be things which would be missed if the accounts were prepared in the ordinary course of events and according to accounting standards. For instance, in situations where they may have been missed due to error or a non-invoicing issue, a third party who hadn't bothered to issue claims or invoices for the debt so that they were recorded in the books and records of the company. Have a think as to whether or not the usual accounts warranties are going to be sufficient. I'm going to hand over to Tina at this point, but do stress there's a lot of authorities on the handout. Don't worry, they're going to be They're going to be set out in the written handout, which comes out to you with all the references and all the detail. In the time fail, that's very much a whistle-stop tour, and I'll put myself on mute now and hand over to Tina for the remainder of the talk.
Thank you very much, Mark. So I'm going to speak for 5 or 10 minutes max about a couple of cases, one involving the mitigation of loss principle in the context of a breach of warranty claim, and the other is in the field of indemnities, and in particular, whether or not the buyer is limited to the contractual measure of damages, or whether in fact it can claim for reliance losses, which would not normally be possible. So turning to mitigation of loss, that's a concept I'm sure everybody's very familiar with, generally in terms of the common law duty to mitigate, as it's normally referred to. And the context here involved in the equity case, which is referred to on the slides, and the full quotation will be in the handout. It's an interesting case. It's a very lengthy judgment. And it's interesting really because, well, for two reasons. One, the actual facts, which related to a biomass boiler and a contract that was entered into with one sole client by the vendor company Gaia. And essentially Gaia had agreed to commission and install 2 biomass boilers, and Green Energy, its sole customer, which was effectively next door to it on the Humber, and was in the business of selling biomass energy, was essentially prepared to take the steam. Essentially, it was a supply of steam from Gaia as a result of the installation of these 2 boilers. So Equitix essentially agreed to buy the entire share capital of Gaia. So it was a share sale agreement, and it had a number of warranties and a mitigation of loss clause in the event of a breach of warranty. I think the second aspect that's interesting about it is the extremity of the facts as found by the judge, Mr. Justice Kerr. I mean, in short, this was a complete disaster from beginning to end in relation to the purchasing, commissioning and installation of these boilers. Essentially, they never ran properly. And in 2016, when this share sale agreement was signed, it was plain and obvious from the facts as determined by the judge that the vendor knew that these boilers were an unmitigated disaster. They hadn't been commissioned properly, they hadn't been installed properly, and essentially they were not being run properly. It was so extreme that there was one particular individual who was effectively in charge of the operation of these boilers. And at one point he was cross-examined on an email that he'd sent to the potential purchaser, where there'd been an ongoing, long-winded course of negotiation where essentially the vendor had not set out truthfully the position in relation to these boilers and the way in which they had been operated. And this particular individual, who was effectively in charge of operating the boilers, had written an email to his superiors, effectively suggesting that he could either set out the truth or he could set out a nice email to the potential purchaser in relation to the questions that were being posed. So it was quite an extreme case in relation to the extent of the breaches of warranty. So I suppose that is the context in which this mitigation of loss clause came about in terms of its scrutiny. And that, I think, has to be borne in mind, because whenever you're considering a mitigation of loss clause, inevitably you're in a position where a judge is looking at that through the lens of the wronged party or the innocent party. And so it's well known and often said that the duty to mitigate is a pretty low threshold. And so that was the context in which the court essentially came to look at this mitigation of loss clause, having found over almost 100 pages that every single warranty that was in issue had in fact been breached by the sellers. So you can imagine that when the court came to construing the mitigation of loss clause and assessing whether or not the innocent party should in fact have its breach of warranty and the damages that were found to flow from that reduced in some way or other because of its own alleged failure to mitigate its loss, you can imagine that the mood in the courtroom. So in terms of the clause itself, we can pick that up at paragraph 399 of the judgment. I'll read it out just because it might assist in terms of understanding the point that I'm about to make. But bearing in mind that the judge had found that in relation to the breach of warranty claim, that the true value of Gaia's shares, rather than the 14.45 million, so almost 15 million pounds that Equitix had agreed to pay and had paid for these shares, that the true value was in fact 1 million. So you can imagine that was a significant breach of warranty claim in terms of its value. And just to recap, because it's relevant in relation to considering mitigation of loss, in share sale agreements, where you're looking at an as warranted and breach of warranty claim, then the normal measure of damages is a breach in terms of a breach of quality, which is what, generally speaking, the warranted clauses relate to, is the diminution in value. So that is the difference between the as warranted value, which here was almost 15 million, and the true value, i.e. once account is taken of the falsity of the warranties. So the difference there was some 13.45 million. There was in fact a contractual cap, but even so, the court found that the value of the breach of warranty claim, taking into account the cap, was 11 million pounds. So that's the backdrop in which the court was then asked by the sellers to effectively determine that the purchaser had nonetheless acted in breach of the mitigation of loss obligation. And the court was considering, essentially in that context, a contractual mitigation of loss clause, which I'll read out. In addition, the court was asked to consider the common law position, but the contractual clause, which was in Schedule 5, paragraph 15.1, said as follows: the buyer, so that's Equitix, shall procure that the company, so that's Gaia, the company running these boilers, the company whose shares were being sold, shall take all reasonable action to mitigate any loss suffered by it or the company which would, could, or might result in a claim against the sellers. So she'll take all reasonable action to mitigate any loss suffered, and not only Equitix itself, the buyer, but it shall procure that the company shall take all reasonable action. So the position put forward by the sellers was that was in effect a beefed up version of the common law obligation to mitigate loss. And that was the issue as to whether it imposed any greater duty on the buyers than the usual low threshold. And it's just worth reminding ourselves what that is, because it was restated by Mr. Justice Kerr, and he effectively said that what needs to be borne in mind, that the common law threshold, which is often referred to as a duty, effectively is a deductibility principle, which is the claimant cannot recover for loss unreasonably not avoided. So it's not whether or not there were reasonable steps that the buyer could have taken and didn't. It's whether or not it was unreasonable to not do so, and it's worth remembering that. So the first point that Equitix took on this was that it tried to persuade the judge that despite the fact there was an express contractual clause dealing with mitigation of loss, that in the context of this sort of claim, i.e. a breach of warranty of quality, and the normal measure of damages being a diminution in value of the shares, that there was no place at all for a mitigation of loss clause, and that effectively it was OTOs and the court should effectively ignore it. Now, the court made some interesting observations in relation to that point. Firstly, the court accepted that generally, so absent a mitigation of loss clause in a share sale agreement, then the common law duty, so-called, to mitigate loss probably has no place in relation to claims for breach of warranty. in relation to warranties for quality in the context of share sale agreements, because if you think about it, there is really no opportunity for the buyer to mitigate loss, because the loss crystallizes upon purchase, because of the way in which the value is in these share cases. It is determined the normal way, which is the as warranted versus the true value. So there is no mitigation and there's no relevance to mitigation. So the court then had to determine whether the presence of an express mitigation clause altered that at all. And in fact, the court did find that if there is an express mitigation of loss clause, then that does bite. And even in a scenario where you're dealing with breach of warranties involving breaches of quality in relation to share sale agreements, if the parties have gone to the bother of effectively drafting a mitigation of loss clause, then the clause would have meaning. And so the court then went on to construe it. But interestingly, the court actually construed it, not in the way that the sellers were trying to persuade the judge to construe it, because they effectively were saying that it was a beefed up version of the common law duty. It wasn't merely a replication of it. And they were trying to persuade the judge because of the two particular references that I stressed earlier in relation to this clause, to take all reasonable steps and to procure that not only that the buyers did so, but the company itself, that they effectively, the sellers tried to say that it was akin to a best endeavours clause, which imposed positive duties on the buyer. The court disagreed and essentially said, look, this effectively looks and sounds like the common law duty to mitigate. It is a low threshold. And then the court went through essentially all of the factual points that the sellers were trying to assert that Equitix failed to do. And effectively, the court found that what they were putting forward on a factual basis were reasonable steps, rather than that could have been taken but weren't, rather than steps that the claimant should have taken and unreasonably didn't. So that's often the case with mitigation of loss. When you're actually litigating, you have to be very careful to put to the witnesses, not that this was an alternative reasonable step, but it was unreasonable to not have taken it. And the judge, and I think, again, based on the backdrop of the failure and the woeful failure in relation to the breaches of warranty, basically gave the vendors, the sellers, very short shrift on all the factual points that they put forward, including the fact that because of this one customer, there had been a fallout that hadn't been properly disclosed. And what the judge said was that this particular express clause was a low threshold and there was no need to take proceedings against that customer, because the customer had essentially ended the contract not long after the purchase, the share purchase. And it was being said by the sellers that the new buyer should have pursued and even entertained litigation against that sole customer for trying to end the contract, and the judge had none of it. So I think the lesson there is that it's probably always worth inserting a mitigation of loss clause, but I think you're going to have real difficulties in persuading a court that in inserting such a mitigation of loss clause, particularly where the breach of warranty is one of quality, that A, it should bite, and B, that it imposes any higher threshold than the common law duty. So that's equity. And the next case, and the final case, involves trucks, and it's the MAN AG case and Freightliner, and this is in the context now of an indemnity. So the facts there are interesting and unusual for this particular reason. So MAN AG, if anyone is familiar with trucks and that industry, is a German company effectively involved in heavy industry. And MAN AG decided it wanted to effectively strengthen its position in the UK truck market, and it set its sights on purchasing what most people will probably be familiar with, a pretty well-known brand called ERF. And that company had in fact earlier been purchased by a Canadian company. So it was quite a complex web of agreements that the court was looking at, and the litigation is extremely complex, involving a number of contributory claims by the defendant against various entities. But in short, the unusual fact about MAN AG is that when purchasing ERF from this Canadian company, there was a Mr. Stephen Ellis, who was effectively the head of finance, and he'd risen up the ranks and he'd been at ERF for decades. And essentially, this whole claim revolved around him. And it was common ground that essentially Mr. Ellis had essentially systematically abused the VAT reclaim system on behalf of ERF, and had for years essentially fraudulently manipulated ERF's statutory accounts. So this claim arose in that very odd context where all the parties agreed that Mr. Ellis had in fact committed fraud, and indeed as a result there was very little argument that there had been breaches of the warranties, including in relation to whether or not the accounts had given a fair and true view of ERF's business. I mean, the facts were extreme to the extent that I think the share purchase agreement had effectively provided for a purchase price of some £65 million. And it turned out that when Mr. Ellis was eventually rumbled, and it took some time, even once the purchase had completed, MAN AG were very taken with Mr. Ellis and continued to employ him effectively as head of finance for the ERF truck division. But essentially, once they discovered what he'd been up to, it meant that ERF had gone from turning a small profit to effectively suffering losses of about 100 million a year. And ultimately, it was very quietly subsumed into the German production line and rebadged eventually. But the point about the case in relation to the indemnity is, so Mr. Ellis essentially being the fraudster and having effectively fraudulently manipulated the accounts to the actual vendors. So there was an interesting, and if anybody's interested in that aspect, there's a very interesting section on vicarious liability in relation to tort and fraud and agents and that sort of thing. But ultimately, what was in play in relation to Mr. Ellis was whether or not the indemnity that was given would effectively sound in the usual contractual measure of damages, or if not, could the indemnity itself provide for reliance costs. And this was important on the facts of this case, because once MAN AG had purchased the ERF, it was essentially pumping millions and millions and tens of millions of pounds into it to keep it alive before it realised why it was hemorrhaging so much money. And so it was trying to claim those reliance costs. Interestingly, Mr. Ellis himself, and I should probably say that Mr. Ellis himself didn't do any of this for personal gain, which is a very unusual feature. And in fact, he even gave evidence at the trial. And the trial judge observed that it took some courage for him to do so, with no real reward or benefit other than perhaps just being able to explain himself. But ultimately, the indemnity in issue was worded in such a way that it allowed for recompense for damages suffered or as a result of any breach of warranty or misrepresentation. Now, the claims that were pursued by MAN AG, unsurprisingly, were claims not wholly in relation to the breaches of warranty. So they essentially were relying on the tort of deceit, and they succeeded on that. But they also relied on fraudulent misrepresentation in addition to breach of warranty. Now, at the beginning, Mark mentioned the fact that, unless the parties have agreed otherwise, then a breach of warranty a representation will not amount to a warranty and a breach of warranty. So they're mutually exclusive, as it were. But the facts here were different, because the clause in issue actually provided, the actual share sale agreement actually provided for the fact that the vendors were not only warranting, but explicitly set out that they were representing, and that Man was relying on those representations. So that's the context, which is perhaps why peculiarly the indemnity was drafted in the way in which I've explained. So in that case, the court actually construed that widely and determined that it would, in fact, provide for inaccuracies both in relation to representations and warranties. And as a result, the court was prepared that damages for reliance costs could be recovered unless they were unconnected with the misrepresentations. So on the facts of that case, hopefully, given what I've explained, you can understand why unusually the court was prepared to award reliance cost damages. And so in relation to indemnities, that might be an interesting case, both in terms of drafting, in relation to the need to make it very clear that the parties are agreeing that there are warranties that are also being relied on as representations, and explicitly set out that the purchaser is relying on those representations, of course, because reliance is part of the cause of action for misrepresentation. So extreme on its facts, but still useful, we believe, in relation to potential pitfalls, and making clear that if you want to, in fact, try and rely on representations as well as warranties to effectively provide for that, not only in the recitals and the actual agreement, but in relation to the indemnity clause itself, which, as Mark mentioned, often go hand in glove with the warranty. So I think that's everything from me. But as Mark said, we're happy to deal with any queries on the chat after the talk. Thank you.
Thanks, Dee. We've got one question which is just flagged up and it's this: can I ask whether acknowledgement of reliance clause mandatory or merely a helpful clause to have in an SPA for buyers to prove reliance on warranty, or do courts generally prefer to examine parties' conduct prior to conclusion of SPA to determine reliance, instead of treating acknowledgement reliance clause as conclusive of reliance? My view on that, and that one of the authorities that we refer to actually has an interesting discussion on this point, and that I'm trying to just think which one, the Belfairs Management Authority, where the court in that case considered the purpose of the warranty in terms of the loss thing. The standard approach is you should have, certainly if you're a purchaser, you definitely want that clause in there for an acknowledgement of reliance clause, because you're going to say, well, I'm relying on all these warranties. What it won't impact on is, whilst it'll establish, because it's brought as a breach of warranty claim, it's a breach of contract claim. So the reliance, doesn't matter where it comes in, is calculating the loss and damage, which will be discussed in one of the later seminars. But the answer to your question is, yes, you should have that clause in, but the court will still look at the conduct when determining what loss has been suffered by the parties, i.e. what impact did it really have in the decision to purchase and the value which was paid for the same. Thomas asking a question about the cause, take on the court's analysis of the relevance of causation in relation to breach of warranty. I'm not going to tread on other people's shoes on that one, because that's going to be dealt with later. We've had to promise on our talks what we will cover on limit, but that will be dealt with at a later stage, because that is a very interesting issue on once you establish the causation. Thank you to everybody for joining. We will be sending out both the video, the PowerPoint and the handout. If there's a delay in you receiving anything, please contact Chambers and we'll make sure you get copies. Thank you for joining us and enjoy the rest of your day. Take care.
Thank you.